Hi guys. Okay, so I popped back on because I used my Google alert to update me on all the logging projects. And over the weekend, the Black Ram project popped up in my email. So Google sends me an email whenever anything hits the news about the Black Ram. Well, what happened was the Yak Valley Forest Council had sent out an update that the lawsuit that Center for Biological Diversity, Alliance for the Wild Rockies, Yak Valley Forest Council, Wild Earth Guardians, you know our group, our list of groups, they had taken against the federal government for stopping the Black Ram project. They had actually won that. The federal government and the Kootenai tribe got their lawyers to get it to the 9th District Court of Appeals, and that court hearing took place on Friday. No decisions have happened yet. But just to briefly reiterate for you guys, they're trying to make this area of the Yak go roadless. So they're arguing a lot about whether or not humans should have the ability to access this portion. For those of you who live there, this is immediately dangerous. If you remember right, the big fire we had in the Kootenai was because they were not allowed to enter it with fire trucks to stop the fire because it was an IRA. That was a portion of a Wilderness Study Act areas. So I'm not going to say too much, but watch the hearing and we got to find out what the results of this will be.
Good morning, Your Honors, and may it please the Court. Jacob Ecker on behalf of the federal government. I'd like to reserve 3 minutes for rebuttal. Unless the Court has questions about the jurisdictional issue that Alliance raises in their second brief, I'll rest on the brief on that question because it's squarely foreclosed by this circuit's precedent. The Black Ram project will increase available forage habitat for grizzly bears and decrease high-intensity wildfire risk. The Kootenai Tribe of Idaho supports the project, and the forest is within their ancestral homeland. The Forest Service and the Fish and Wildlife Service made well-founded factual and scientific determinations on both the effects of the project itself, which are not at issue in our appeal, and on the background issues that Alliance and CBD raise here. Those background issues are existing unauthorized use on the forest and the existing population size of grizzly bears on the forest. The district court failed to give adequate deference to the agency's discussion on these issues, and this court should reverse. I'd like to start with the unauthorized road use issue. The court ought to reverse the district court because, as I mentioned, it failed to defer to the extensive discussion that the agencies provided. I'll start with NIFMA. Under NIFMA, the National Forest Management Act, the Forest Service must determine that every project that it considers complies with the forest plan itself. As you just heard in the previous argument, forest plans are more programmatic documents. Here, we're talking about one specific project. So the terms of the forest plan itself are a given, and the question here is how did the forest plan implement them?
The access amendment definitions of roads don't distinguish between authorized and unauthorized road use.
That's correct.
Why shouldn't the agency be required to include the known documented unauthorized road uses?
So the agency does include chronic unauthorized road use. The forest plan focuses on the permanent condition on the forest. So when a type of road use in a specific area is chronic from year to year, as is the case with Forest Road 5890, discussed at 5 ER 1130, the Forest Service does count that use. The question here is when the Forest Service detects one instance of unauthorized road use and has made a broad determination that typically across the forest, based on its experience monitoring over the years and in response to plaintiffs' specific photographic submissions, the question here is whether the Forest Service reasonably concluded and whether that conclusion was based on substantial evidence that certain types of road use, certain types of unauthorized use are not chronic and are sporadic and do not need to.
I'm just looking at ER 1806. The routes used to establish the permanent condition are those that are authorized routes. Unauthorized use features are not. That is, any user-created routes or access as well as breaches are not considered part of the existing condition. Importantly, because we address discovered or reported unauthorized use promptly, and because in our experience unauthorized use on any given route is not chronic from year to year, such use does not contribute to a long-term or permanent change to the route's database.
Is that
So
8 ER 7? I'm sorry.
1806. 8 ER 1806. So it seems like you're saying because we don't think that unauthorized uses really exist because we address them so promptly, we don't need to consider them.
So, two responses. First, that quote reflects the Forest Service's understanding of how it ought to be implementing and operationalizing the forest plan itself, which does focus on the permanent conditions on the forest. So, when you have instances of one sporadic use of a road, what the Forest Service has determined is that, it's being as diligent as it can be to prevent that from happening on the front end. It's monitoring and correcting problems as they arise. And yes, there is a certain amount of road use that occurs that the Forest Service is not able to prevent. It acknowledges that, it does its best to prevent it, and where it is pervasive and it can't be corrected, the Forest Service counts that against the access density metrics.
Where is it clear in the record that the Forest Service counts that type of chronic unauthorized road use in assessing in the road conditions?
Sure. So the discussion that Judge Koh just flagged talks about sporadic uses. Those are the types that it doesn't count, and that, I think, discussion is there. On the other side of the line is what the Forest Service thinks of as chronic road use that repeats.
Well, I have the reports here. Why don't you give me an ER site? And I can...
Sure. So I'll give you this is a site to one of the monitoring reports. I believe I had it a second ago, 5 ER 1130. What the Forest Service explains there is that for Forest Road 5890, which I think is referred to as Gun Club Road in that specific page, that is a chronic use. The Forest Service has not been able to prevent repeated use in that area. And so what it considers is that, okay, we have a route that is consistently being used illegally, and to the point that it is essentially seeing the same level of traffic and therefore the same level of impacts to bears as an open route. And so that's a line drawing exercise that the Forest Service made and determined that on one side of the line you have sporadic uses, and on the other side of the line you have chronic uses. That's also consistent with prior guidance from the District of
I just want to make sure
Montana.
I understand your argument in the end. So you're saying Forest Road 5890, also known as Gun Club Road, it's illegal to use that road, but because illegal use is chronic, you treated it as if it were a road where there was authorized use for the purposes of your analysis.
That's right. Even though it was illegal, the Forest Service still counted it.
Okay. And then in the, my other concern about the statement that Judge Koh read to you is that one of the assumptions built into the statement was when there is a barrier that's breached or broken, we fix it promptly. And then there seems to be quite a bit of evidence that that doesn't actually happen promptly. And then the rebuttal evidence that you cited doesn't seem to actually rebut that, as far as I can tell.
So that's incorrect, Your Honor. The Forest Service, for the past several years, so the forest plan requires monitoring of at least 30% of gates every year. The Forest Service has monitored much higher levels, nearly 100% in recent years. So the Forest Service is going out, and I think the plaintiff's
So where in the record is the evidence that broken barriers are fixed promptly?
So I would say the annual monitoring reports reflect every time a barrier is breached that it's noted, and then when it's scheduled for repair. So I think the most concrete application of this is at 8 ER These are the two submissions that the Yak Valley Forest Council submitted to the forest in 2021. Those are at Volume 8 and Volume 9, and I'm blanking on the precise numbers here. They're cited in our briefs at page 32 through 35, I believe, on our third brief. Those reflect that the Forest Service, in addition to its annual monitoring, actually went out to every site that the Yak Valley Forest Council flagged. In the July submission, it was 20 sites. In the November submission, it was 55 sites. It went out, and for each site, it took its own photographs and made its own notations about, okay, well, on 4 of these 20 in July, we do see some tire marks. We see one broken gate. They scheduled the gate for repairs, and they noted the routes as a user-created route. So the record as a whole, the monitoring reports and the Forest Service's responses to Yak Valley Forest Council's submissions reflect a diligent actor who is trying its best to make sure that these roads are actually closed.
Right, but I think in the Forest Service, in the record in the Forest Service's own documentation, it indicated something like, and I'm not going to remember the exact numbers,
Sure.
we detected this many breaches and then we repaired this many, and it was a very small percentage. I don't see any other, I mean, it seems great that you're monitoring, but then the assumption that all these breaches are repaired promptly does not seem to have evidence in the record.
So
Yes, you responded to somebody else saying these ones need to be fixed, but that doesn't seem to me to support the assumption that the Forest Service is systematically detecting and promptly repairing breaches.
So I will readily admit that the Forest Service has limited resources and schedules repairs as they're possible. The record in this case ends with the decision document in 2022. I'm certain that the Forest Service has continued to schedule repairs for after that time.
I certainly have sympathy for the lack of resources
Well-
in repairing breaches. The problem I have is the assumption that's built into the analysis that says we detect and repair them promptly. So it just seems counterfactual to what you're saying, is that we don't actually have the resources to repair them all promptly. Then why was that assumption built into the analysis?
Well, so I have two responses to that. I think taking a step back from that, I think it's really important to note that these individual breaches don't necessarily reflect chronic road use at all. So you still have the background, the kind of stepping back question of, does this create a permanent change in forest conditions? I mean, you may have a gate that is broken, but I think most forest users would still see a gate and realize they shouldn't cross, and it's still illegal to do that. Now, I will readily admit the Forest Service is not able to repair every gate immediately, but the fact is that that doesn't equate to actual unauthorized use. And so the forest plan itself requires only actual unauthorized use be counted. So that's one problem. I think the broader problem is that when you are...
Let me understand that point. You're saying a breach just shows one-time use.
Not necessarily.
It doesn't show continued use. Is that the point you just made?
So my point is that I think it's really up to
And what's your evidence for that, right?
The Forest Service has to determine when it goes out to look at a gate what's going on. So it does look at tire tracks. It looks to see where people are going and tries its best to figure this out. So, breaches can range from a 10-minute trespass in the middle of the night to a repeated use like Gun Club Road, where they do count it. And I think my broader point is that it really ought to be
Okay, so then
the Forest
tell me,
Service.
what is the criteria of when you count it? A
Forest-
one-time midnight use is not counted.
Well,
That's
so
what it sounds like.
it depends on
And
what you mean by counted.
What's
Yeah.
the criteria?
Depends on what you mean by counted. So
Mm-hmm.
when the Forest Service, for example, went out in response to Yak Valley's submissions, they did record user-created routes. If those routes continue to see use year over year, those will eventually become chronic problems if they're not able to correct it, similar to Gun Club Road. But what the Forest Service knows from its experience on the forest is that by and large, those...
Okay, well, this is what I'm interested in. What is your criteria for when it has to be, counted for purposes of this is a road that's being accessed? Okay,
Yes,
so
Your
you're
Honor,
saying
so-
you have to have year over year use to count.
That's right.
So
the Forest
how many
Service-
years? How much use per year? I guess, and
Sure.
where is any of this in the record? Because the only, the statement that I read in the record is pretty much what I can tell the Forest Service says. So all of this information that you're providing, can you give me a record site of where you actually have this criteria open so the public can comment on it?
So I'll point again to the annual monitoring reports, because that's where the Forest Service goes out and determines. And one of the monitoring reports talks about this gun club road where they see repeated use. That's where they talk about the idea of chronic uses being those that count against density.
It still doesn't answer the question of what metric does the service use to say this use has gone from non-chronic to chronic?
The Forest Service has to see use in at least more than 1 year. I don't know at what point it tips over the line. I haven't seen.
And where is that definition of that methodology
in
the record? I'm hearing this actually for the first time.
I understand the court's concern. Mm-hmm. The Forest Service is implementing something that is silent in the forest plan itself. So this is really an application of a standard to specific facts on the ground. So what we're dealing with is, as you read, Judge Koh, that's on one side of the line. The temporary, non-chronic use that's sporadic.
But why
and that's a
wouldn't
factual
this
finding that the Forest Service
disclosure be
makes.
important so that the public could comment on it?
Well, I mean,
if there's all this criteria that the Forest Service is using and it's, from what you say, silent.
I don't think there's any problem here with public comment. I think the Yak Valley Forest Council and others have consistently petitioned the agency to look at this stuff, and the agency's done so. I think that the diligence is reflected in the Forest Service's responses to those comments. And I would just encourage the court to look at the Probert case.
There's a substantive standard that the service has to comply with, and the service took a position that we don't have to count certain unauthorized use because it's not chronic and because we repair breaches promptly. Now, the second assumption has been, I think, not defended as supported by evidence in the record. And you said, well, that's essentially a harmless error that we made an incorrect assumption because actually the use is not chronic, so there's still no problem. But now we're just, how are people, essentially that's a,
I understand.
If the use is actually chronic,
sure,
or it is actually having an impact, there would be a substantive violation. So there needs to be some criteria for determining whether it is chronic or not.
I understand the court's concern. I think the explanation that the Forest Service provided, and I just want to take a step back again. This is not about the effects of this project itself. This is a background issue. So I think the level of detail that the Forest Service needs to go into is somewhat lessened. I will not say that does not make the issue important. I think the Forest Service really pays attention to this stuff. I think when it notices chronic use, as with the Gun Club Road, it counts that use against its metrics. And I think that the district court was too demanding.
It just seems like in Knotty Pine, the Forest Service made the same arguments, right? Use is not chronic, we repair it promptly. And there the district court said, no, you do need to include it in your road density calculations. So it just seems like...
And we think that was wrong. I mean,
What was wrong? That it was factually wrong or that it was wrongly decided?
It was wrong to require both in, and I'll focus on this case because this is the case on appeal, but it is incorrect to require only one methodology of the Forest Service. When the forest plan itself does not specify how the forest ought to be dealing with this, the Forest Service has discretion, and to the idea that it must count something because, because there's a 1 or 2 times trespass.
I don't think anybody is saying that.
Okay.
Right, but I think it. But certainly, if there were chronic use, then I think you are acknowledging that would essentially have to be counted then as any other road for which there is authorized use. And the problem is that Forest Service's assumption as to why it should treat certain unauthorized use as non-chronic is not supported either by criteria or evidence in the record.
I don't think that's...
you're saying, trust us, we check for it, we build the barriers, right? We fix the barriers when they're breached, but the evidence in the record, at least, is counter to that assumption.
I don't think that's right. Let me first take the standard question. So the district court the District of Montana in 2019 in the Probert case remanded to the agencies to consider unauthorized road use that it knew to be chronic. That was what was remanded to the agencies. And after that, going forward, the agencies no longer make any assumption that road use is not chronic just because it's illegal. So now, in cases where it is chronic, following the guidance from Probert in 2019, the agencies count that use. When it's not, I understand Your Honor's concerns about specific individual breaches, but the Forest Service is monitoring every year, and I think getting to that level of granularity is inconsistent with the APA's standard of review.
Can I ask one quick question? You're over your time. All right, the federal defendants are not joining the tribe in its appeal of the center's first claim. Is that right?
That's right.
Okay. So then who would bear the burden of proving harmlessness if the federal government is not appealing that? Is it the tribe or is it the plaintiffs?
So my understanding of the harmless error rule under the APA is that the plaintiff typically bears the burden of showing prejudicial error. Now, we haven't taken a position on that in this case, but we do have a discussion of harmless error elsewhere in our brief with respect to our NEPA issue. So you may find some guidance in case law in that section.
And why isn't the federal government joining the tribe in that appeal of that claim?
That's a decision that rests with the Solicitor General. We haven't been authorized to join that, and so I can't take a position on that.
Okay, but generally it would be the government's burden to show harmless error, right?
I don't think so. I mean, that's not consistent with my background understanding, but I haven't taken a position in this case.
Okay. All right, thank you.
Thank you.
You've gone over your time
That's
by
right.
5.5 minutes, but I'll give you 2 minutes for rebuttal.
I appreciate that, Your Honor. Thank you.
May it please the court, my name is Julie Wise and I represent the Kootenai Tribe of Idaho, and with me today is the tribe's Attorney General, Mr. Billy Barquin.
Welcome.
Your Honors, the tribe urges the court to affirm the district court on the no jeopardy determination, but to reverse on 3 issues: the unauthorized road use, the ESA baseline issue, and the NEPA existing condition issue. It helps to understand why the tribe is here, so I'm going to start with that. The Black Ram Project is located in the tribe's Aboriginal territory. That is the area where the tribe has reserved rights for hunting, fishing, and gathering. And the tribe's creation story is central to why the tribe is here, because it holds that the tribe was, the Kootenai people were put on this earth to keep the Creator Spirit's covenant by guarding and keeping the land. And by doing so, the land in return would provide for the people forever. This project is consistent with that purpose, their main purpose. And it is consistent because it is consistent with the tribe's own proactive and holistic approach to land management in Kootenai territory. The tribe historically employed fire on the forest landscape with the creation of the national forest that stopped, and the result has been a forest that is much less resilient and that endangers natural resources. So the tribe is very focused on restoring the resiliency to the forest, protecting those natural resources, and protecting the people, because that lack of resiliency also actually threatens people living particularly in the wildland-urban interface, where people and their property are in really close contact with these natural resources on the forest. The project will treat wildland-urban interface. There's only 3,900 acres of commercial harvest in this project, and 38% of that, the record shows, is in the wildland-urban interface. The record also shows that there have been many fire starts over the last decades in the wildland-urban interface. So it's really important to allow this project to proceed. And of those resources that the tribe is so concerned about, one of them is the grizzly bear. The tribe is committed to conservation of the grizzly bear, and in fact serves as a representative on the interagency grizzly bear committee for this particular ecosystem, the Cabinet Yaak ecosystem, this recovery zone. So the tribe understands that it's important to actually restore the forest so that you can protect all the species, including a species of great importance like the grizzly bear. I had intended to jump right to the existing condition issue, but I'd like to first address a few points, if the court would, on the unauthorized road use. Your Honor, Judge Koh said that the forest plan doesn't talk about unauthorized versus authorized roads. Well, it also does not talk about it does not define the term effectively restricted. And we explained in our brief that this issue of effective restriction dates back to 1994 when the Interagency Grizzly Bear Committee recognized that they needed to have some consistency on how it was talking about these roads. And it, first of all, came up with a definition in 1994 at 8 ER 1891 that a restricted road requires physical obstruction, generally gated, and motorized vehicle use is legally restricted. Now, the word effective restriction came into play 4 years later in 1998, and the word effective was added. You'll find that at 5 ER 1038, and the IGBC added the definition and said a restricted road requires effective physical obstruction, generally gated. It did not define the term effectively. And the biological opinion that is currently in place for the forest plan relies on that 1998 report. If you look at 5 ER 1000, that's term and condition number 1 in the biological opinion, it says when managing motorized access, the forest shall use devices or methods on restricted roads that are consistent with those recognized by the IGBC, and then it cites that 1998 report. So we have this issue of the Forest Service needing to make sure that these roads are effectively restricted, but there's no definition of effective restriction. And this is important because we know that under Ninth Circuit case law, including Weldon, cited in the brief, it's at 697 F3rd 1043, the Penn site is 1056, the Forest Service's interpretation and implementation of a forest plan is entitled to deference. And respectfully, the district court did not give any deference. And it's important that this court not fall into that same trap of trying to second guess what the agency was doing, because the agency is going out there and trying to do the best it can to make sure that the grizzly bears are protected. And the Kootenai tribe totally supports that effort. If you look at Gassman, the Gassman decision that we cited, that is, I believe that was, I'll give you the site for that. Gassman was at 2023 Westlaw 4172930, a recent unauthorized road use case out of the District of Montana. The court said, well, in this case, okay, we've got the situation in Martin 1 where it can't be speculative. You actually have to have some evidence. And then we've got the situation in Probert where, you know, a lot of evidence, okay, that's unauthorized use, that's arbitrary and capricious. In Gassman, it was in between, and the court said, you're more like Martin 1. You know, this is more like just speculative unauthorized road use. And that's important because Gassman actually found an earthen berm rate failure of 35%. And the district court in this case recognized that effective closures are not 100% effective at reducing unauthorized road use. So I think the proper analysis here is you have to look at the totality of the evidence. No one case is going to be determinative. We know there has to be something more than speculation, and evidence like in Probert was enough. But importantly, please, Your Honors, take a look at that 2020 Bear Year Monitoring Report, because this case is about a project. It is about a site-specific project. And we know, based on that 2020 Bear Year Monitoring Report, we know at 5 ER 1115 that in the 2020 Bear Year, there was no unauthorized use in those units. The units in this project had no unauthorized use. We also know at 5 ER 1117 that there was only one instance of unauthorized use involving a user-created road, and that was in Unit 15. Your Honors, also, if you look in the record at 5 ER 1130, there's email correspondence where the Forest Service explains, well, Unit 14 doesn't really have an issue because it has its location and difficult terrain mean that there's very few instances where people are going to go into that area. Unit 15 is a little bit different, and they said that they are promptly remedying the breaches, except for to your point, Judge Sung, about where do they say that they deal with chronic roads, they said except for Road 5890, which is treated as permanently open due to chronic unauthorized use. So this is a case, Your Honors, where we're talking about a site-specific project, units 14 and 15, that appear to have very little, if any, unauthorized use. And we have to think about the difference between Martin 1, where the court said, okay, speculation is not enough, and Probert, where really hard evidence, a lot of evidence of unauthorized use is enough. This case is in between, and it really is much farther down to the Martin 1 situation where these unauthorized use allegations are speculative. The last point I will make on that is if you look at the tribe's, the disputed statement of fact, where we went through the actual photographs that had been submitted on these, all the photographs of allegedly breached gates and berms and things like that. The Forest Service identified, as government counsel said, one by one by one by one. And there was no problem. This is speculation. This is like Martin 1. And for those reasons, the court needs to defer to the agency's interpretation and treatment of its forest plan. I'm happy to answer any questions of the court regarding the other issues in the case, including existing condition, which we do believe that the existing condition was harmless error, that we demonstrated the difference in the number of bears between 2020 and 2017 was not significant. In 2020, there were estimated 60 bears, and in 2017, it was 55 to 60. So new data would not have made a difference here. And the tribe does not support encyclopedic looks at issues that don't rise to the level of significance, particularly where doing that simply delays the protection of natural resources of importance to the tribe. And the court should have recognized that the harmless error rule, which needed to be applied in this situation, indicated that new additional evidence would not have made a difference.
But why wouldn't have other data in the updated study, like recent bear mortality, not impacted the Forest Service's analysis? And why wouldn't it have, at least have a material impact on public participation?
Your Honor, the public was able to participate fully because the number of bears was the same.
But their comment may have been different, right, if you had all of the data that was in the updated study?
If they had all of the
including on recent bear mortality.
The recent bear mortality, actually, Your Honor, the information shows that the bears are only trending upward. We cited in page 33 of our brief, it's the continuation of footnote 7, that the 2022 data now has the estimate up at, I believe, 65. The most recent report that's available publicly online has the number at 67. So there is no indication that, I think perhaps you're thinking of the mortality, Your Honor, that was discussed in the context of the ESA baseline, that mortality is included in the analysis at all times.
Right, I'm not talking about that issue. We're talking about the harmless error on the
yes.
the appeal that the federal government is not joining you on.
Yes,
yes. You're over 5 minutes over your time.
Yes.
Let me see if my colleagues have any more questions for
Thank you.
Okay, thank you very much.
Thank you
for the helpful argument.
Good morning, Your Honors. May it please the Court, my name is Andrea Zaccardi. I represent Appellees and Cross Appellants Center for Biological Diversity, Yak Valley Forest Council, and Wild Earth Guardians. This case challenges a commercial timber sale.
Since time is limited, I apologize for interrupting, but I do want to go to the argument we just heard from the tribe about Claim 1, I believe, which is where the district court found error on the use of the older report versus the newer report to determine the baseline. And I understand the tribe's argument to be because the numbers for the baseline only improved, that was harmless error. And when I read your response to that, I see you conflating your argument about what should have been consulted in the baseline and saying, well, it wasn't harmless error because they actually shouldn't have been consulting the reports at all, but they should have been consulting what we consider to be the proper measure for the baseline. Do you have any other response to the harmless error argument made by the tribe?
Yes, Your Honor. I'll start by saying that the burden is on the agency to show harmless error.
Yes.
The agency here didn't even argue harmless error. Only the tribe did. So I will make that point clear. But
what's the significance of that the federal government is not joining? You're saying then it's the tribe's burden?
well, it's at least the party seeking to have the ruling set aside, and we do have citations for that if you need them. But the main problem here is that over the past several years, grizzly bear mortalities have been increasing. And at the exact same time, detections of grizzly bears have been decreasing. From 2018 to 2020, we saw 4 female mortalities and 2 cubs of an unknown sex compared to 2015 to 2017, where we only had 1 female bear killed.
So I see you citing, if I'm understanding you correctly, you're essentially going back to what is really your argument about how to determine the baseline and how to determine population growth and mortality. The service's response was, we're going to look at this report. We think that's the best scientific method, and you disagree with that. So the numbers you're citing are from your method, not the services. Is that correct?
No, the numbers I'm stating are actually from the case from annual reports.
From the report. So the 2 reports that are issued, because my understanding is the error identified by the district court was consideration of, I believe, the 2018 report versus a 2021 report. I might have the years slightly off, but these are 2 reports. My understanding of one of your claims is they shouldn't really be using these reports at all. Right, they should be using the counts.
No, not at all, Your Honor.
Okay.
We don't take issue with anything that the Fish and Wildlife Service has considered in reaching their population estimate. We're not challenging the model. There's no direct challenge there. The problem is there is recent available biological data that the Fish and Wildlife Service doesn't analyze at all in the biological opinion.
Okay, well, I read the district court's opinion as saying there was an older report and a new report. The failure to consider the newer report was error. And then I read the tribe saying, well, that was harmless error because the information in the 2 reports actually only shows improvement. Can you address that argument?
Yes.
With specific sites to the record.
So the harmless error argument only goes to the Forest Service's analysis in their environmental assessment. The Forest Service analysis, the data that they used only went up until 2017, even though the environmental assessment was published in 2022. So there's absolutely no data from 2017 to 2022 included in that EA. That is the document that goes to the public for public comment. So the public has no idea what's happened to grizzly bears, that these mortalities have been increasing, that detections have gone down.
So what is the specific difference in information between the 2 reports that you're saying would have materially affected public comment or the Forest Service's decision? Can you point me to something specific from one report to the other that changed that you say would have materially affected either the decision or public comment?
Yeah, so there's several reports, but at 4 ER 749, which is I believe the 2021 report that has data going through 2020.
Sorry, can you give me that site again, please?
Sure, it's 4 ER 749. Mm-hmm. That is where we see that there's been 4 times as many female grizzly bears killed than the last previous 3 years. And that's actually those female grizzly bears is as many grizzly bears that actually have been killed from 2009 to 2015, so even the previous 7 years. And then that trajectory, unfortunately, has only continued. So in 2002, we had 3 female grizzly bears killed, and Fish and Wildlife Service biologist Wayne Caseworm said that's the highest number of female grizzly bears they've seen killed in any single year since they began monitoring back in 1983.
I guess the question I have is, I'm looking at the CASWORM 2021 report, and it seems to pretty extensively discuss mortality. If I look at 4ER 749, 4ER 765, 4ER 771, and you have the declaration from CASWORM, who is the biological scientist who did this, who said, look, we are considering mortality in our analysis, and just doing tree rubs and these sort of one-off isolated, that's not scientifically best available science. So why isn't the agency entitled to some deference on this?
So, Your Honor, the annual report that you're citing to is not the biological opinion. So the agency action needs to be upheld on what the agency articulated in the biological opinion. Just having that report in the record is not enough, and Ninth Circuit case law is very clear on that.
But that's what the Fish and Wildlife Service relied on for its biological opinion, was this report.
They relied on parts of the reports for sure, but they
and
didn't
the report,
address the fact that mortalities are rising and detections are going down at the exact same time. As for the detections, you're correct that the biological opinion said that you can't consider the drop in detections, or actually it didn't reference the drop in detections, just you can't reference detections in general as the sole population estimate. And we've never said that. We've never said you detected 50 grizzly bears, so you take that number and say that's the population. What we're saying is when you have an increase in mortalities and a decrease in detections at the same time, that is important information that the agency should be considering, especially with a project that is going to move forward and impact grizzly bears negatively additionally. And this information it's important information that the agency didn't consider, because the grizzly bear population growth and persistence relies on female grizzly bears that are successfully reproducing and rearing young, and the biological opinion says that survival and reproduction of each individual grizzly bear is very important for this small population to survive.
So would you agree
and
for the
recover.
jeopardy determination, there's a difference between slowing the rate of recovery of the grizzly bear versus appreciably reducing the likelihood of recovery? There is a difference, correct?
There is a difference, Your Honor. I think on the jeopardy claim.
So why wouldn't any temporary impact to the reproduction of a few individual female grizzly bears just be slowing the rate of recovery versus, appreciably reducing the likelihood of recovery?
Well, even though we're only talking about 3 female grizzly bears, that's actually nearly 20% of all adult female grizzly bears in this small population. So we're not really talking about minimal numbers, even though the agency tries to frame it that way. And they say that temporary impacts won't be a problem, but we're actually talking about female grizzly bears that may not be able to reproduce for 1 to 2 reproductive cycles. That means they're not rearing young that also reach adulthood and reproduce and contribute to this population in the future. So I think the impacts are actually a little longer than the agency is willing to admit. While I admit that it's impossible to calculate how long those impacts will impact the recovery of this population, I think it's longer than the 5 years that they say will be the impact. And 20% of female grizzly bears is a pretty substantial number. And it's also important because this project area has been specifically really important for female grizzly bears over the past several years. The area for decades has supported reproductive females that have contributed to the population. And as recently as 2021, which is the year before they finalized the biological opinion, there were 2 known reproducing females observed in this action area.
You are a minute and a half over your time. Let me see if my colleagues have any more questions for you. No, I'll just give you a few seconds to wrap up. Thank you.
Okay, thank you, appreciate it. In conclusion, we ask that the Forest Service affirm the district court's holding that the Fish and Wildlife Service violated the ESA and the Forest Service violated the National Environmental Policy Act by disregarding information, and that you reverse the district court's finding on no jeopardy.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Rebecca Smith, and I represent the Appellees, Alliance for the Wild Rockies, and Native Ecosystems Council. I'd like today to just respond to 6 questions that the Court just asked to opposing counsel on the Access Amendment road issue. Starting with Judge Sung, you asked, you couldn't remember the exact numbers, but you were discussing the issue of whether roads are promptly repaired. The citation for that is 5 ER 1068. And the numbers there were that in the only monitoring report the Forest Service has included in the record, 32 barriers were breached, 0 were repaired, 40 gates were breached, 9 were repaired. And as you noted, although the government on appeal in oral argument today is making arguments that it does fix things, it's just not in the record. We just don't have that in the record before the court. Similarly, Judge Koh, when you asked where is the methodology that says how and when they determine whether a road has become chronic enough to include in the road density calculations, you asked where is that method in the record, and the answer is that it's not in the record, and that does make it an impermissible post hoc rationalization under the Supreme Court's well-established precedent in State Farm, 463 U.S. at 50. This court may not accept counsel's post hoc rationalization for agency action. So
my understanding of the service's argument on the repair issue is, well, we are limited in resources, so we can't actually repair all the breaches as quickly as we'd like, but that assumption or statement we made is essentially harmless because it still remains true that the unauthorized use is only occasional, not chronic in these areas, and that we have evidence of that because we monitor, and when the use becomes chronic, we do in fact treat it appropriately. Can you respond to that argument?
yes, Your Honor, I'd like to address that in 3 ways. First, by looking at the project-specific biological opinion, then by looking at the forest plan biological assessment, and then by looking at the district court's decision in Probert, which the Forest Service appealed and then withdrew its appeal. So first, on the specific issue of whether illegal use is a reoccurring problem in this project area, the U.S. Fish and Wildlife Service at FER 0922 stated that it did have the Forest Service's annual monitoring reports, and in this action area, so in this project area, there was, in fact, illegal use in at least, it says, 3 of the 8 years. I'm sorry, the citation is 2 ER 263. According to data provided by the Forest, from barrier 2012 through 2020 monitoring reports, illegal motorized use was observed in the action area in 3 out of the 8 years. So this is a reoccurring problem. Second, the Fish and Wildlife Service goes on to say that it looked at those public photos from the Yak Valley Forest Council, and what it found is that those photos corroborated illegal use. It says that the Yak Forest Council's report highlights multiple gated or bermed roads that may have been bypassed by all-terrain vehicles or motorcycles. In addition, a few user-created routes. The reports further corroborate data from the forest. That's 2 ER 263. So the Fish and Wildlife Service did not, as the interveners do, just dismiss the Yak Valley report as false. They looked at those pictures and they found that those reports were valid and corroborated data from the Forest Service. Second, Your Honor, I want to...
So is your position that that level of use actually makes it chronic?
Thank you. Yes, Your Honor, and that goes to the issue of probert. The DOJ today, the Forest Service Council, gave a sort of brief summation of probert that was actually inaccurate. What happened in probert was that prior to 2020, the Forest Service did include illegal motorized use in its calculations. You can see this at 7-ER 1544, where they say, this is the Forest Service in 2020, to err on the side of the bear and show all potential effects. If illegal motorized access has occurred on a restricted route, the route is analyzed as open for the entire bear year, even if the route may only receive little or short-term use. That was their position in 2020. They did include that illegal use. And the reason that matters as it pertains to the probert case is that probert was therefore able to take calculations that included illegal use. And what Judge Malloy found in probert is that when it looked at the illegal use in the calculations, those standards had been exceeded in 8 years. He was able to take illegal use, legal use, put them together and find that together those numbers actually exceeded and violated the Access Amendment standards in a number of years. And so what he found, though, was that it wasn't illegal use on the same road any particular year. And so he said, in this year it might have been this road, in this year it might have been this road, but when we look over time, every single year we end up with the forest plan violation. And so that's really the important distinction for the court to understand here, is that's why he found a chronic violation of the Access Amendments in probert was because it was the illegal use that over time was leading to those forest plan standards being violated year after year. Not anyone's...
I thought that before today, the defendants were arguing because the Access Amendment is vague about whether and how you count unauthorized use, the agency should be given deference. But then what I heard today is, oh no, we're very specific and it's in the record, here are some sites that this is how we treat unauthorized use. So tell me what you think about, am I right that there seems to be a slight change in position, or am I just misunderstanding the two? And if it is the first, that there's actually ambiguity such that the agency should be given discretion, then why shouldn't we defer?
Thank you, Your Honor. The agency's long-standing position would be the only position entitled to deference. The long-standing position up till 2020 was to include illegal motorized use, even short-term. And again, that's at 7-ER 1544. This is the first case where they're arguing that they can exclude illegal road use. And the argument you heard today at oral argument is one that we don't find in the record. That's not in the NEPA methodology section for the EA. So that is a newly formed argument. And so it is entitled to zero deference. And another factor that you look at when determining whether to afford any deference to a Forest Service interpretation of the forest plan is that you first have to start by looking at the plain language of the forest plan itself, the definitions that are in the forest plan itself. And so if we look at what the definitions actually say, the intervener cited to the IGBC document from 1998, that's not the forest plan. We have to look at the forest plan record of decision and the glossary and the definitions that were actually codified into the forest plan, not any other document. The forest plan definitions say open motorized route density must include all roads not meeting restricted or obliterated criteria. Total motorized route density must include all roads not meeting all reclaimed criteria. Restricted roads must have an effective gate. A reclaimed road must no longer function as a road. That's at Alliance's SER 131. Gated roads must be effective. That's at 126. impassable roads must
Let me
prohibit.
ask just one last question because we're running
Okay,
out of time.
thank
and
you.
We've heard a lot of argument today, and I'd like to wrap this up. So if the agency defined the core and open total motorized route density and explained that route densities would be calculated with GIS applications, why is that insufficient in explaining its methodology?
Your Honor, because the most important factor here is what the impact is going to be on the imperiled Cabinet Yaak grizzly bear. That is the whole point of the Access Amendment. And so the fact that they are now for the first time excluding known motorized use that we know is going to harm that population, that known illegal use, that definitely needed to be disclosed to the public in the environmental assessment. That is the Cabinet Yaak grizzly bear is maybe the most important issue to the public here, and the most imminent threat to grizzly bears is roads, including illegal roads. And so,
Okay, but I guess I'm unclear. You're saying that they made the argument of excluding illegal use for the first time in this case, and I guess the first time today. Is that right? Then what was your previous argument that there was a procedural violation based on then? If this is what you're saying, post hoc rationalization, just come up today, then what was your previous procedural defect that you had trouble with?
the previous procedural defect was that the NEPA methodology section of the EA did not disclose at all how they calculated road density. Today, to this court, they proposed a methodology that's just not in the EA either. So before the argument was more, there's no disclosure at all. Now, today, our argument is shifted to, they just gave you a method, but that's not in the record.
I think there's a little bit of confusion that I have in terms of your choice of the word methodology, and maybe it's trying to fit it into the case law. The method for determining how to classify roads, I guess, was the use of the GIS monitoring that seems to have been disclosed. What I see you as arguing is it's the fact that they sort of viewed a certain amount of unauthorized use essentially as de minimis that was not disclosed adequately. Am I understanding your argument correctly as what they should have more clearly disclosed and did not?
Yes, Your Honor, maybe I should have used the word calculation
Okay.
as opposed to methodology. The calculation should include the illegal roads as it did always prior to 2020, because that is a critical factor that harms grizzly bears.
Okay.
All right, do my colleagues have any more questions? Judge Sung? All right, thank
Thank
you
you,
very
Your
much for
Honor.
a helpful argument. And you're welcome not to use your time. You're already over 5.5 minutes of your 14 minutes.
I understand, Your Honor, and I appreciate the additional time. I'd like to first clarify, we are both asking for deference on the Forest Service's implementation of its plan, as we asked for in both our opening brief and the third brief, and as we discussed today, substantial deference to factual findings. Our opening presentation and the court's questions primarily focused on factual findings, and so that's where we focused our attention. But the argument has always been that the access standard 2 itself does not speak to this issue. The Forest Service is entitled to deference on that issue, and its factual findings about how to apply that Forest Service plan, access standard 2, to the facts ought to be given deference. I'd like to give the court a site that did not occur during the COVID-19 pandemic for monitoring. 5 ER 1069 is the site, 1068 to 69, my friend on the other side cited to. Other years show up to 80 or more % of gates were fixed. 4 ER 853 is the site for that. And I would just otherwise point to the additional monitoring reports that are throughout the record. Beyond that, I think we rest on our briefs, and I would urge the court to reverse with respect to unauthorized use, reverse with respect to the population density or population size estimate, and affirm with respect to jeopardy.
All right, thank you. Let me just check with my colleagues. Judge Sung, do you have any more questions? No? All right, thank you. Thank you to all counsel. These were very helpful arguments. This case is submitted, and we're going to take a 10-minute break.
All rise.
Good morning. Welcome back. Thank you for your